My name is Darren Keys, and I'm president of the Fort Worth Lawyers chapter of the Federalist Society. And right now I'm honored to introduce my friend Jace Yarborough, the moderator for our panel entitled The Intersection Between Individual Expression and Parental Rights. Jace is a principal at the SL Law Firm, a conservative plaintiff's side litigation boutique that was recently in the news for their representation of Elon Musk's X Corporation. Jace is also a reservist in the United States Air Force and serves as a major in the Space Force. And prior to his current firm, he was with Baker Botts. He received his law degree from Stanford and 2 bachelor degrees from the University of Texas in Austin. Jace is a 7th generation Texan, grew up in rural Texas, and married his high school sweetheart. He is now a father of 5 and the founder and headmaster of St. Francis Academy, a classical Christian farm school serving families in North Texas. And on a personal note, Jace is an articulate man of great intellect, but more importantly, he is a man of deep faith, unwavering principle, and a humble warrior. Jace.
Wow, thanks, Darren. I appreciate that. It's my privilege to be here this morning. Those who are students of Lewis may remember this line from The Abolition of Man, a book that bears directly on our topic this morning. Quote, "Hitherto the plans of educationalists have achieved very little of what they attempted, and indeed, when we read them, how Plato would have every infant a bastard nursed in a bureau, and Eliot would have the boy see no man before the age of 7, and after that no women, and how Locke wants children to have leaky shoes and no turn for poetry, we may well thank the beneficent obstinacy of real mothers, real nurses, and above all, real children, for preserving the human race in such sanity as it still possesses." Given the rising insanity of our own culture, we could describe this morning's panelists as defenders of that beneficent obstinacy, which may yet preserve us from the worst excesses of our unbounded conceits and ideological mania. It's therefore my pleasure to introduce, starting with my immediate left, David Hacker. David is Vice President of Litigation and Senior Counsel at First Liberty Institute, where he oversees all of First Liberty's litigation. Prior to joining First Liberty, David served in various appointed positions in the executive administration of the Office of the Texas Attorney General, including as Associate Deputy Attorney General for Civil Litigation. In addition to his public service with the Office of the Texas Attorney General, David spent over a decade at a national nonprofit organization litigating civil rights cases across the country, including matters on First Amendment, due process, equal protection, and Title IX issues in higher education. He began his career in the litigation department of a major Chicago law firm, and he also serves on the board of directors for his children's classical Christian academy. Immediately to David's left, Tim Davis. Tim is a partner at Jackson Walker in their trial and appellate litigation divisions. Here in Fort Worth, part of his practice, he represents a number of government entities and political organizations and candidates, including many of the school districts and school boards here in North Texas who have been at the forefront fighting for parental rights in public education. So very much practical experience in what we're talking about this morning. To Tim's left, Mandy Drogan. Mandy serves as campaign director for the Texas Public Policy Foundation's Next Generation Texas, which focuses on results-based K-12 higher education and workforce development solutions. She is an education reform leader here in Texas who, as president of the recently formed Texas Federation for Children PAC, helped elect numerous pro-school choice candidates to the Texas legislature and defeat opposing incumbents in the 2020 and 2022 election cycles. Prior to joining TPPF, she was at the American Federation for Children for nearly 8 years, where she served as the state director. And then to Mandy's left is Ryan Bangert. Ryan is Senior Vice President for Strategic Initiatives and Special Counsel to the President at Alliance Defending Freedom. He oversees ADF's regulatory practice, government relations, and corporate engagement teams. He also advises executive leadership with strategic initiatives and appears as counsel for ADF clients. Before joining ADF, Ryan served as Deputy First Assistant Attorney General and Deputy for Legal Counsel in the Office of the Texas Attorney General. Prior to his government service, he was a litigation partner at Baker Botts, where he was a member of the firm's commercial litigation and appellate practice divisions. Ryan earned his JD from Southern Methodist University before clerking for Judge Higginbotham on the Fifth Circuit. Please give it up for our panel this morning. So we're going to start with brief opening remarks from each of our panelists. So with that, I will turn it over to David. We'll just start from my immediate left.
Okay, well, thank you. And if there was any doubt that the Federalist Society provides fair debate on various topics, they have allowed a native Californian to be a speaker at the Texas Chapters Conference. So thank you for allowing me to be here today to the local chapter, and I look forward to our discussion. I'm going to just say a few things at the beginning here, and one of the things I want to do is tell you a story of two states. The first state leans conservative. It has Republicans in leadership positions in the governor's mansion, the legislature, and many of its congressional seats. It generally protects civil rights, sometimes even taking aggressive positions to move the law nationally. The second state is dominated by Democrats and has been for several decades. It has a bad track record on civil and constitutional rights, and is not a state that many of us would want to live in. The first state is, of course, California, until about the 1950s. And the second state was Texas until about that same time, when both of those states began to flip. Now, if you'll excuse my generalization about their political makeups, my point between comparing these two states is that we cannot always expect the leadership of our state and the laws that our elected leaders enact to always respect the rule of law, to respect individual rights, or to interpret the Constitution according to its original meaning. We must expect that over time, the political leadership of our state and local governments will change, and we must be prepared for those changes by vigorously protecting religious liberty, individual expression, and parental rights while we can today. Because today, in California, the legislature passed a law just recently that prohibits schools from sharing the gender identity of students with the students' parents. In California, parents in custody proceedings can lose custody of their children if they don't affirm the child's new gender identity, because lack of affirmation under the law is equivalent to abuse. In California, the public school system is actively driving a wedge between what parents teach their children at home about morality and the human condition. It directs teachers to integrate DEI and other gender ideology in as many aspects as possible in classroom teaching, starting as early as kindergarten, and then actively tries to hide that teaching and that curriculum from parents and prevents them often from opting their children out of the instruction. And as a refugee from California who fled that state because of those types of things for the blessings of liberty in Texas, we have to remember that as we discuss the intersection of individual rights and parental rights today, my point, the point that I want you to walk away with, is we must not think that we here in Texas are immune from these dangers and these things that are happening in California just because we do live in the great state of Texas. We have to be vigilant in protecting these rights. And we have to ensure that we secure these blessings of liberty, not just today, but tomorrow for our kids and our grandchildren. You know, they used to say that as California goes, so goes the nation. I hope that's not true, and I hope that we here in Texas can flip that and make it so that as Texas goes, so goes the nation when it comes to protecting parental rights.
Yeah, well, thank you, all of you. Thank you to all of you for just helping our self-esteem. We know we're not as popular as the judge panel, and so you all are making us feel good about ourselves. But thank you also, Jace, and these panelists. Unlike Judge Branch, I really am asking the question, well, why am I here? I mean, these folks are very distinguished. These folks are leaders in this area. And I think the only way that I can really answer that is that I, like many of you, am a parent. I have a 4-year-old at home. I have one on the way, and I love them deeply. And so I'm deeply concerned about these issues and about what's happening in our schools. A part of my practice is representing school boards. In Texas, school boards are different than school districts under the Texas Education Code. And so I get the privilege of working with boards that are really on the front edge of so many of these parental rights issues in different ISDs around North Texas. As a result of that, I get to see what's happening inside of these schools. And some of it is very concerning as a parent. Some of it is very concerning to see what my son may go and encounter in a classroom, go and see what my children may learn or hear from other classmates or from those who we are paying to educate them. And so that's why this issue to me has been so important in the last few years as it's become part of my practice, as some of my friends have gotten elected as school board trustees, and as many of you all have sent your children to these schools and you have seen what's happening there. I think that parental rights is a discussion that is as old as our civilization, but it's now fresh again because of the things that we're experiencing in the culture.
Hey y'all, I'm Mandy Jogan. I might be the only non-attorney in this room. I'm just a mom. I'm a mom of 3 little kids. I have a 7-year-old, a 5-year-old, and a 3-year-old. And I've been on a mission for the past decade, but really in the past 4 years here in the state of Texas, as we've watched the erosion of just common sense, the parent empowerment movement has been spreading across Texas, and it's made up of the 4 pillars of parent empowerment. As the beacon of freedom that we as Texans see ourselves being, we wondered why red states all across America, and quite frankly, blue states as well, 32 other states plus the District of Columbia have some form of private school choice. Why has Texas not had that? So we went and did some psychological message testing, AKA polling, out across Texas. And we found that when you walk through a 4-point sequence, you move Texans across the board, Black, white, Hispanic, any other race, Republican, Democrat, Independent, any political affiliation, to a 90-10 supporting issue for parent empowerment and school choice. So I'm gonna walk through those really quick with you so you know the lens we're coming through. The 4 pillars of parent empowerment starts with transparency. Number 1 is transparency. Every single parent across the state of Texas has the right to know what their child is learning and why they are learning it. If you're like me, you've sat and watched, and you were talking about what you're seeing in the schools, you see these culture wars, this indoctrination that's going on in our classrooms. We have so many reports of kids being broken up by their skin color and their hair color for history lessons. I have parents calling me talking about privilege walks going on. Just this year, many districts, one very close to this, where we are today, I had a parent call me and say her kid was lined up on the baseline of the basketball court and asked, if you have 2 parents at home, take 2 steps forward. If your parent has a college degree, take 2 steps forward. If you're white, take 2 steps forward. Now look around, kids. That's privilege. This is the victims. These are the victimizers. That's the oppressed. These are the oppressors. This is going on all across Texas. If you're like me, you grew up with posters on your wall. My elementary school had the same laminated poster everywhere with Dr. Martin Luther King and a bubble coming out of his mouth talking about how he wants to see his children. I have a dream that my 4 children will one day live in a country where they are judged by the content of their character and not by the color of their skin. And yet, across our state, we are teaching kids to judge everyone by the color of their skin. We also have straight up pornography in our libraries. I'm not talking about some graphic cartoon images. I'm talking about telling our kids how to engage in every type of sexual activity that you can imagine. These are in our classrooms. Radical leftists are indoctrinating our kids from kindergarten, asking their pronouns. This is going on. Every parent deserves transparency into what their child is learning and why. Number 2 is quality. Across the state of Texas, according to the STAR results, 50% of our kids cannot read on grade level. But if we look at the NAEP scores, that's the nation's report card, we find that only 23% of 8th graders can read on grade level. 60% of our kids can't do math on grade level. We have a crisis of low expectations. It is in our classrooms. Commissioner Mike Morath of the Texas Education Agency recently disclosed in a House Public Education Committee hearing, they did an internal audit across our public schools and found that just 19% of the curriculum is on grade level. That soft bigotry of low expectations is plaguing our state all across the board. So number 1 is transparency, number 2 is quality, and number 3 is respect. Respect for parents. We are the ultimate decision makers for our child's education, care, and what they are learning. But if you're like me, you've watched far too many times where parents are on social media or in the news because they've showed up at a school board meeting and their hair is on fire, y'all. They are mad as a striped snake and they are going at it. But I remind people all the time that no parent sets out to embarrass themselves or their kids in front of the entire state, jeopardize their careers, or anything else that is following, get arrested. Here's what happened. Something was going on in a child's classroom. And mom or dad sent an email or they went and knocked on the door. Excuse me, teacher, we need to fix this problem. I don't know if it's their IEP isn't being met. I don't know if the child's being bullied to the point of self-harm or suicidal ideation. I don't know if they're one of the 40% of kids in Texas that are still not being taught to read using phonics. I don't really know what it is, but it's the same thing every time. Can we fix this problem, teacher? No resolution. So mom or dad shows up and says, excuse me, principal, can we fix this problem? No resolution. And if you're like the mom that showed up to talk to the governor and myself with tears strolling down her face, she says, that's my story. Except I went all the way to the superintendent of my district. My second grader was being exposed to highly inappropriate sexual materials by her teacher. And the superintendent proceeded to tell me if I didn't like it, I could go somewhere else. She was crying because she said, I can't afford to go somewhere else unless I have an education savings account. Parents must be respected as the ultimate decision maker for their child. And the fourth pillar of parent empowerment is choice. Every single parent, regardless of their skin color, the money in their bank account, any other deciding factor, they must be in charge and have the choice of where they send their child to school or how they educate their child. Those are the 4 pillars of parent empowerment, and that's what swept the state, and that's what I'm going to answer questions on.
See Jace looking at me, so I think that's my cue. So a couple of things to follow up on. I think Mandy did a great job of outlining many of the practical threats to parental rights that are facing us today. I want to take a step back and talk about why we should care about parental rights and try to articulate why parental rights are an issue today when maybe 10 or 15 years ago, it would not have been something that you would have put at the top of your list of issues as a conservative to be worried about. And I want to start with sort of a macro view, which is I think we're sitting at a pivot point or a hinge point in history right now. Whether you know it or not, we are sitting at what Os Guinness, the philosopher from UK, calls a civilizational moment. There's a book called The Fourth Turning by Ian Howe, who explains this as a moment in history where the foundations of our society are being questioned and in some ways shaken. And one of those foundations that has run sub rosa in the conversation for a long time is parental rights. And those rights have really never been questioned seriously, but they are being questioned right now. And that's why we are experiencing these conversations that we're having on the stage today. They are foundational because if we go all the way back, I'm going to do my best Judge Kaczmarek imitation and talk about Aristotle for a moment. But he talks about the family, or the oikos, being one of the foundational units of society. Civil society cannot exist without the family. The family, of course, can exist without civil society. It is a foundational unit of civil society. William Blackstone wrote that the family is the most universal relation in nature. Professor Melissa Moschella has argued, one of the leading scholars on parental rights today from Catholic University, has argued that the authority of parents as the authors and the generators of a family is natural and original, not conventional or derivative of the authority of the state. So it is a foundational thing. The U.S. Supreme Court in Parham versus J.R. even wrote, our jurisprudence historically has reflected Western civilization concepts of the family as a unit with broad parental authority over minor children. So this is something that is foundational to our society. The second point I want to make is parental rights today are in conversation. They are in conversation because their boundaries and their content has not been well articulated by our courts and has not been a source of meditation by our public intellectuals for some time. Why? Because they have not been seriously in question until now. I think that there are two different strands that define this conversation over parental rights. One is something I would call the parent-centric model of parental rights. This recognizes parental rights as something that is a natural right. It's a right that springs from the very fact that parents have natural custody over their children, and they are related to something called duties, parental duties. And this is actually reflected, believe it or not, in Texas statutory law right now. Texas Family Code, Section 151, actually lists parental rights and parental duties in tandem together. I've got a copy of it right here. First section, Section A parent of a child has the following rights and duties: the right to have physical possession, to direct the moral and religious training, and to designate the residence of the child, followed by Section 2, the duty of care, control, protection, and reasonable discipline of the child. So this is a parent-centric model. Parental rights spring from interlocking duties and rights. Duties to children, because children are brought into the world through parental and marriage relationships, but also rights to discharge those natural duties. The state cannot interfere with those rights. Why? Because the family is precedent to the state. There's a second vision right now, though. I would call it the parent-centric, the child-centric vision, but it's really the state-centric vision. There's a professor, Jim Dwyer, at William & Mary College of Law, who I debated last year. And he is one of the primary authors and advocates for the child-centric vision. And he has this incredible quote in one of his law review articles. He said, "It is naive to think that courts can always determine what is best for a child." I agree with that. But then he continues, "It would also be naive to think that parents are always more competent to judge their child's best interests than are state agency personnel who spend their lives studying and thinking about what is best for children." So this child-centric model of putting the interests of children first is really a state-centric model. It's the model that says the state defines what's in the best interests of children. That definition controls, and parents simply have privileges to carry those interests into effect so long as that parental work is being done consistent with the state's vision for what's best for the child. So these are competing visions that impact the way that our policy debates are being carried out right now. And I want to close with this. These two visions, the conflict between these visions, as Thomas Sowell would say, is very apparent right now. Think back to 2021, the COVID lockdowns. What did we see? The National School Board Association sends a letter to Attorney General Garland, motivated by a conversation that we later found out about with the White House, in which the NSBA said that parents are acting like domestic terrorists because they're advocating for the rights of their parental rights to influence and affect the education of their children. In other words, protesting the lockdowns of schools, protesting the exclusion of their children from education. And for that, for simply advocating for their kids, parents were called domestic terrorists by the trade group that represents all school boards in the United States. And why was that? Because the vision of the NSBA, the vision of the White House at that moment was what's best for kids is that they not go to school. They be excluded and locked out of their classrooms. And if that vision is not supported by parents, then they are domestic terrorists. That's why the parental revolution led to the election of Governor Youngkin in 2021. I think David already mentioned, though, the pushback has been severe from the left. California, as David mentioned, has passed a law very recently that prevents schools from notifying parents if their children are being secretly transitioned at school. The school is taking custody of kids and saying, I know what's best for the kid. I know what's best for the child, and that is we're going to recognize their autonomy to define their own reality. If they believe they are a furry, or they believe they are something of their different gender or different sex, we're going to honor that. We're going to honor the child's autonomy. And if the parent gets in the way of that decision by the state, well, too bad. We're not going to let them know. Why? Because this is a state-centric, child-centric vision of parental rights. Now, thankfully, Elon Musk decided to move, I think, SpaceX to Texas. I think he already decided that, but it was a great press release to say, I'm going to move SpaceX to Texas because of this outrageous law that was signed into effect by Governor Newsom. And so I think that this is the conversation we're having today. There are two visions of parental rights. These two visions implicate the foundational nature of parental rights. We're at a pivot and a hinge point in history on a number of different issues. This is just one of them, but it's a very important one because parental rights are foundational to our liberty as a society.
Thanks, panelists, very much. So I'm going to ask questions. I'm going to direct them to an individual to make sure that we as an audience benefit from at least one answer. But other panelist members, please feel free to chime in on any of these. So Mandy, first question to you. We're here to talk about parental rights, among other things. What is a parental right?
Non-lawyer.
That's why you're here. Yes, ma'am.
Parental rights are unalienable rights endowed by our Creator to raise our children up in the way that they should go, which would include the right to direct their education, their health care, and their well-being in the care that they receive.
Amen.
Nope. Go ahead, Ryan.
Did I get that one right? Good.
Always trust the non-lawyer on this.
That's right. There you go.
It's an outstanding definition. I mean,
Okay.
parental rights they precede, they're not positive rights, they are natural rights. And I think
right.
that's where, if you look at the philosophers who talk about parental rights, they're natural rights that spring from the natural relationship between parents and their children. And of course, Edmund Burke called the family the little platoons of society that ensure liberty for all.
So Ryan, where can I find parental rights in the Constitution, right? What are the statutory and common law protections of and for parents as they exist today? And shouldn't I, as a member of the Federalist Society, be somewhat leery of an unenumerated right, assuming that maybe is where you're going to go?
Well, yes, they are unenumerated rights, but I mean, if you look at the court's definition of how to discern unenumerated rights in Glucksberg, these are rights that are deeply rooted in the nation's history and tradition and implicit in the concept of ordered liberty. There's nothing more implicit in the concept of ordered liberty than the right and the duty of parents to raise, to form, to educate their children, because it's foundational to society. In fact, in Dobbs, where the court unpacked some of the meaning of Glucksberg, the court specifically called out the line of cases, Pierce and Meyer. I think David's going to talk about those in a moment. Where the court recognized parental rights as fundamental. So they're not enumerated specifically in the Constitution, but there's zero question in my mind that the Constitution protects them as fundamental under the Glucksberg test.
So David, turning to you, can you give us a sense of the legal landscape as to parental rights today? What are the major precedents, court decisions? How have recent cases drawn the line between parental rights, government power, free expression?
Yeah, sure. And apologies for basically kind of doing a short law school class here, just as a refresher for all of us. But let's go through some of the major precedents that we've seen from the Supreme Court. Meyer versus Nebraska was 1923. This was a teacher at a religious school who taught the subject of reading, or literature as we'd call it, in the German language, and was convicted of violating a Nebraska statute that forbid teaching any school subject in any language other than English unless the child had reached 8th grade. And so SCOTUS overturned that conviction and grounded its decision in the Due Process Clause of the 14th Amendment, which makes us all kind of feel icky here at the Federalist Society. But it held that the, quote, liberty protected by that clause includes the right of parents to, quote, establish a home and bring up children, and to, quote, control the education of their own. And it was kind of interesting, in going back and looking at that decision, the court also said that this liberty interest included the right to worship God according to your conscience and to enjoy the privileges long recognized at common law. A few years later, in Pierce versus Society of Sisters, this was a challenge to an Oregon law that made it a misdemeanor if you didn't send your kid to public school when they were between the ages of 8 and 16. The Society of Sisters, who operated a private school, challenged the law, and the Supreme Court affirmed an injunction against it and held that the law unreasonably interfered with the liberty of parents and guardians to, again, direct the upbringing and education of children under their control. In 1944, the Supreme Court kind of threw a little bit of a curveball in Prince versus Massachusetts. There, a mother who was a Jehovah's Witness was convicted of violating state labor laws for bringing her child with her to pass out tracts on the sidewalk. The Supreme Court held that the state's interest in prohibiting child labor was paramount to this woman's First Amendment and 14th Amendment rights. And here we say that the court is indicating for kind of the first time that parental rights do at times have to yield when the state seeks to protect the health and safety of children. In Wisconsin versus Yoder, you'll remember this was the Amish families who were convicted of violating Wisconsin law that required school attendance until the age of 16. They said, that's not how we do it in our religious community, and we have these beliefs that you can go to school through 8th grade, but after that you work in the community. And the Supreme Court ruled in favor of the Amish and overturned their conviction for violating this law. And the court there acknowledged, again, that providing public education was at the apex of the state's power, but that power had to yield to the rights of parents to provide a private education of their choosing. And it said, quote, long before our society decided there was a need for universal formal education, the religion clauses specifically protected the free exercise of religion, including how to teach and what to teach children. So if you were concerned at all about the substantive due process issues that sometimes surround parental rights, rest assured they could also be grounded in the religion clauses. In Troxel in 2000, in a plurality decision, the Supreme Court dealt with this issue of grandparents who wanted visitation rights for their deceased son's daughters. Now, the mother here didn't necessarily oppose visitation in general, but just didn't want the grandparents to have as much time as they wanted. And in the state of Washington, they had this law that said any person could petition for visitation rights at any time. And the mother challenged this through the proceedings, and the Supreme Court ruled for her and grounded its decision, again, in the 14th Amendment, saying the liberty interest in the case, the interest of parents in the care, custody, and control of their children, is perhaps the oldest of the fundamental liberty interest recognized by the court. And so kind of fast forwarding to today and thinking about these prior precedents, we're kind of seeing, like Ryan mentioned, an explosion of issues involving parental rights, not only in the educational context, but also when it comes to kind of the health and safety and the medical care of children. And so there are a few cases that have gone different ways. I'll just give you some examples. One of them was called John Parent versus Montgomery County Board of Education that went to the Fourth Circuit. There, that court held that parents did not have standing even to challenge a school district policy that withheld a student's new alleged gender identity from parents. Again, one of the issues Ryan had mentioned. Out in Wyoming, the District of Wyoming, in a case called Wiley versus Sweetwater County School District, the school there adopted a similar policy directing teachers to use a student's preferred pronouns or name and not tell parents about it. And the court there issued a preliminary injunction against that policy, holding it violated the parents' rights under the 14th Amendment. In another Fourth Circuit case called Mahmood, which is now on cert petition, I understand, the school adopted a gender ideology curriculum for all of its students and required the reading of certain books and additional instruction in those ideas, and originally allowed parents to opt their kids out of this stuff, but then changed course and said, nope, everyone has to go through our gender ideology training. And the Fourth Circuit affirmed the denial of an injunction against this program for the parents had challenged, and held that the curriculum didn't require the parents or the children to change their religious beliefs, so there was really no harm, no foul. California, we've kind of beat up on them, so let's do it some more. They passed a state law preventing schools from requiring parents to be informed when their child begins to use a different name or pronoun, as Ryan and I both mentioned. And interestingly here, two municipalities, the city of Huntington Beach and Chino Valley Union School District, have both sued to challenge that law. And then in another interesting case that was in Minnesota, a Minnesota school district was using, again, gender ideology books in its curriculum in grades 3, 4, and 5, and wouldn't let parents know about this until after the fact, and was really having difficulty even thinking about whether they should provide opt-outs for parents. We represented some Somali Americans who objected to this, who came to America for freedom and liberty and the ability to educate their children according to their own religious beliefs. And so when they objected, we sent a couple demand letters to the school, and eventually the school reversed course and provided some opt-outs for those parents from that curriculum that they objected to. And then finally, just to kind of round out the discussion and look forward to hearing from what my colleagues here have to say, last year, the Supreme Court of Texas, I think, decided what will go down as one of the more important parental rights cases in Texas in many years, which was Lowe versus Texas. This was a challenge to the Texas law that banned gender mutilation for children under the guise of various gender ideologies. And the plaintiffs there said that this violates our parental rights under the Texas Constitution. And the court held that no, it doesn't. It reaffirmed that fit parents have a fundamental interest in directing the care, custody, and control of their children from government interference, but that those rights are not absolute. And the court, I commend the opinion to you, did a very good job of applying the Glucksberg analysis. And I also commend to you some of the concurring opinions by Justices Young and Blacklock, which really kind of lay out the struggle, or what I would call the battle that we're seeing today between parental rights and the state wanting to take more control over children.
Jace, can I just add one quick note to that, what David said? We have this concern about substantive due process being the originator of these rights. 21 states have statutes in place that expressly protect parental rights. So in many states, parental rights are the subject of statutory protection. And I also want to commend to you Attorney General Opinion KP-0241. A number of people in this room, David and I were at the AG's office when it was issued, and there are a number of people in this room whose names are actually on that opinion. And it rolls up all of the cases that David just mentioned and explains how they affect Texas law specifically and how Texas protects parental rights as fundamental in line with those cases, but also in line with Texas statutory law. And then the last thing I'll mention, the Lowe case, which is a fantastic case. I think everyone in this room should read it. Justice Blacklock, in his concurring opinion, lays out what he called two different visions of parental rights as it pertained to the specific issue in hand, which was the question of whether or not the state could prohibit medical professionals from engaging in transition surgeries and pharmaceutical treatments of minors. And there was this big discussion about whether or not parents had some sort of fundamental right to dictate terms to the state, to tell the state, you have to allow us to access these medical services. And I thought Justice Blacklock did a great job of describing what he called the traditional view of gender and sex and the transgender view of gender and sex. He said, this is not a question about parental rights. This is not a question even about medical expertise. It's a question about moral visions in society. And that kind of question is really left to the people's representatives, to the voters themselves. And that in conversation with parental rights don't necessarily allow parents to dictate terms to the state when the state is prohibiting medical treatment. And there's a lot of discussion in the opinion. One thing I'll point out to you that I think is very important, parents do have rights to refuse state-mandated treatments of their children. And so oftentimes you'll see the blood transfusion cases are a great example of that. But that's different than the parent saying, I have a right to tell you, the state, to provide a medical treatment that is generically prohibited for all, that I myself as a parent could not necessarily access. But I'm going to tell you, the state, I'm going to transmute, in the words of the opinion, I'm going to transmute this parental right into an affirmative right to force the state to provide medical treatment. So I think that's a very worthy discussion in the Lowe opinion that I would also recommend to you.
Tim, you mentioned before some instances of some of the things that we're being seen in schools. Mandy touched on that as well. So you become go-to counsel for a lot of high-profile cases involving school boards and parents on the ground fighting back for their children, especially here in North Texas. We'll turn to what these boards and parents are doing in a moment, but first, can you tell us why they're doing it? Why are they taking these actions? What did they encounter, for example, in their local schools that motivated them to act?
Yeah. So as we said before, I don't think this is a new fight. I think it's in a fresh moment just because of what we've seen culturally. But you can think back, I mean, you gave us a case, I think, from the 20s. We started with parental rights. And I think about the Scopes trial that was 100 years ago that was a fight over what curriculum is going to be taught in the public school. But I have a personal story, I think, that probably speaks to this question a little bit. I mentioned I have a 4-year-old, and we live in Southlake, a suburb here, mid-cities between Dallas and Fort Worth. And the very week, very good school system, by the way, incredible school system. It's why we live there. It's why we moved there. And the very week that my son was born, our school board decided to promote what's called the Cultural Competence Action Plan. And it's as bad as that sounds. It was not anything that we wanted for our son. And among its greatest hits, it was going to track microaggressions that were defined as intended or unintended slights. So he could not mean to do something, be disciplined for it, and then they were going to report that to any college that he would apply for. And I remember, those of you that are parents, you remember being a new parent. And I was in charge of the 11 o'clock feeding one night, and I was watching the school board meeting on my phone because it was still going on as they were debating this. And I had my headphone in, and I was holding him in one arm. And so when he's radicalized in a few years, I think we'll trace it back to that moment of watching a school board meeting with his dad. But watching that school board meeting and having the recurring thought of, how did this happen? How did we get to this point? That this is something that we're having to talk about. That this is even a question in our school district and in our town where we all live, and that we're all so proud of. How did we get here? And so as I've talked with those that have run for school board trustees in the last few years, that's been their reaction as well. You said that you're a mom. One of the trustees, it's a school board president here in North Texas. That's her story, and it's not any sort of political rhetoric that she's saying. She really is just a mom, and she got so concerned about this by being confronted by what was happening that she said, I can't, I have to go and run for school board now. So it was a combination, I think, of a lot of things coming out of COVID, out of that summer of love, of fiery, but mostly peaceful protests, and out of just learning all of a sudden and hearing what was going on in these classrooms, hearing that there was a hostility towards certain faiths, that there was a biased view of history that was being taught, that all of a sudden these parents had that moment where they were confronted and had to answer that question of, why is this happening? And then the follow-on question of, well, okay, what are we going to do about it? And that's what I think I've seen motivate most of the folks that I get to work with.
Could I respond to that?
Please.
Yeah, and just thinking about one thing you said about the microaggressions being considered at your local public school district. You know, when I was working for ADF years ago and engaged in campus free speech battles, those were things that we were challenging in court, were these trigger warning policies, speech codes, policies requiring reporting others for microaggressions, and they continue to this day. And one of the things I wrote an op-ed about years ago was that, kind of unlike that catchy Las Vegas commercial, what happens on college campuses doesn't stay. And kind of the bad ideas that the left is promoting and incubating on America's public college campuses are now seeping into the rest of our culture as those students graduate, thinking, oh, it's okay to cancel another person or to shout down people. And we've seen this past year in kind of its worst form with many of the atrocities that have happened at college campuses after the attack on Israel. And so, you know, if you want to understand kind of what you can expect your local public school to be dealing with in the next 10 years, just look at what's happening on college campuses today.
I think it's really important, and this applies to the legal field, the medical field, education, to actually go back further. We're seeing it right now. We've been seeing it for the past decade, 2 decades. But if you go back to how all this started, you could go back to an Italian communist, his name's Gramsci, and he believed that, capitalism and Western civilization was terrible and it must be destroyed. And in his writings, as he was in prison, they're his prison notebooks, he talks about the only way to destroy Western civilization and the freedoms that we love is to destroy 2 institutions, the church and the family, because that is the foundation of Western civilization. That was picked up by a gentleman named Herbert Marcuse at the Frankfurt School in Germany, and he latched onto that and, kind of went on and used that in his communist theory, and then he brought it across the Atlantic Ocean over here to America, to California. And that is where he got together with this young student named Roy Duchke. And the thing is while all of this is going on, Western civilization continues to grow and develop, and the poor become less poor and happier, and they have families, and they have TVs, and they have all these wonderful things. And Viva la Revolution is not going to happen because they're happy, and life is good. And so they realized, well, the workers aren't going to rise up. College students actually stink at organizing, and they won't do it. And so, thus is born the idea of the long march through the institutions. If you can't if you can't destroy it, take it over. So that's where you got this idea of you have to infiltrate legal institutions, particularly the thought leaders. Aside from what we've watched in the past couple years with Yale and Harvard, and no offense if you went to school there, that's great. But you've seen what's going on, okay? And that is because it was very intentional to go in and take over the thought institutions, the associations. We've got the Pediatric Medical Association trying to tell me that my little 3-year-old boy could tell me he was a girl. Like, hello, gametes, chromosomes, I don't know. What are we talking about here? Are you crazy? Yes, they are. And that's intentional because they needed to come in and change the way people think. But it wasn't just in law. It wasn't just in medicine. It got into K through 12 pedagogy. And they did that through the colleges of education. I don't care where you went to college. It's happening in your school. It's happening in your field. And it's important to know that because they're trying to convince all of us up here and all y'all that we're crazy because we believe in natural law and all the other laws that y'all read and make and have read off here. And so it's important to understand how this happened and why it's so important. I won't tell you when I was born, but I was a Reagan baby and raised by some hillbillies from Tennessee that got married when they were 17, 18 years old, but they loved freedom. And so I can remember my father talking to me and reinforcing that freedom is not free. He was a drill sergeant in the Army during Vietnam. My grandfathers fought in wars, and that was crucial to recognize it must be fought for, protected, and handed down to the next generation for them to do the same, or we will spend our golden years talking about what it was once like in America to be free. And that's why when we're talking about parental rights and in the K through 12 system, we have to understand what happened and how it has infiltrated and infested your field and every other professional field, and how they are trying to enforce groupthink. And they're playing the long game, y'all. They're playing the long game. They know if they can get to our kids and start it at kindergarten, right? Sex isn't a thing, it's gender. That's why they're doing it. And that's why all of this is so, so vital for y'all to know that and fight back against it.
Yeah. So thanks for bringing that up, Mandy. So schools are the primary institution of forming our children today, whether rightly or wrongly, which is perhaps why school districts are often at the center of spats over parental rights. So doing our best to avoid making this a panel on education as such, Ryan, what are, after what some describe as much weeping and gnashing of teeth, this school choice legislation was not passed in Texas during this past legislative session. What are the potential opportunities and dangers for parental rights under the most common school choice regimes that are currently implemented?
Yeah, it's a great question. And the temptation is to say, well, school choice will have no meaningful impact on parental rights. But I don't think that's exactly right, but for reasons that aren't necessarily intuitive. I mean, there are a number of states right now. I think 17 states currently have education savings accounts. 14 have traditional voucher programs. 2 are experimenting with tax credit ESAs. So these are very common programs that are they're not uncommon. And Texas is sort of an outlier right now because we're lagging behind. But that has not solved the problem of parental rights in education at all for a variety of reasons. There are 2 reasons I want to give you. One is we are seeing, in response to moves by states to create greater school choice, we are seeing moves by the left to try to use that in almost a jujitsu fashion to limit parental rights. One way we saw that is a case out of Maryland. It was called Buettner-Hartsoe. And it was a challenge to it was an effort by the litigants to apply Title IX, which has been absolutely abused, as Tim knows, by the Biden administration to try to force this radical transgender ideology into federal law. They tried to apply Title IX to a purely private Catholic school on grounds that the Catholic school was a C3 and tax-exempt status constituted a receipt of a government benefit for purposes of applying Title IX, which is just insane. But the Fourth Circuit eventually overturned that, but that was sort of the first volley in this effort. We just saw this in Oklahoma, a case where ADF has partnered up with First Liberty in defending there was a contract between the state charter board and St. Isidore School, which is a Catholic school, that tried to apply to become a charter school under the Oklahoma Charter School Program. And the Oklahoma Supreme Court just 2 months ago said that violated the Establishment Clause. Why? Because by receiving the benefits of being a charter school, St. Isidore became a state actor. So a Catholic school became a state actor, and a state actor, according to the Oklahoma Supreme Court, is in violation of the Establishment Clause because it was educating children in an explicitly religious way. Now that calls into question all the Everson and all of its progeny, which Yoram Hazony has said that needs to be the next target of the conservative movement, is the overturning of Everson, but we'll leave that for a different panel. But the second threat that I see really is not related to school choice, but it's in spite of the fact that school choice is being implemented, because the vast majority of students throughout the United States are still being educated in public schools, over 80%, even with all the school choice programs that have been put into place. And what we're seeing in school after school after school are gross violations of parental rights. A couple of examples of that. 2 ADF clients, Dan and Jennifer Mead, in Rockford, Michigan, had a daughter. She was on the autism spectrum. She was struggling with some mental health issues. She went to see her public school counselor, and this counselor was friends with the parents. They went to ice cream together. And what happened was, months later, the parents got a report back from the school using a male name for their daughter. And they said, well, this is obviously a mistake. They called the school up. Come to find out, the counselor had been urging their daughter to transition to a male identity to treat her mental health issues. Never told the parents about it. The only reason they found out was because the school forgot to change the name in the report back to the female name. And you think, well, that may be an isolated incident. Well, not really. Look at Kansas. We have another case that ADF took on, Rickard versus Geary County in Kansas. Geary County was a school that tried to implement that same policy, not telling parents when children in the schools were transitioning with the school's assistance to a different gender identity. Our client was a Pam Rickard. She's a teacher. She said, hey, that violates my conscience as a believer. I'm not going to lie to parents about what's happening with their kids. So she challenged that rule, and it was amazing, the testimony in court. We got the superintendent of the school on the stand, and what he said was remarkable. He said, well, it's not our job as schools to out children to their parents. It's our job to protect children's autonomy to live their authentic life in the school. And come to find out, the way they had implemented that policy was there was a school app called Schoology where parents could log in to check their students' grades. They had a firewall that was implemented. On one side of the firewall, the school-facing side of the firewall, they used all of the new pronouns and names, but it was converted over to the original pronouns and names when it faced out toward the parents. So there was an actual application being used by the school to lie to parents about what was happening with their kids. Wales versus Jefferson County, another case out of Colorado that we just took on. 2 parents of an 11-year-old daughter who went on a field trip, and it's an overnight field trip. She goes to her room, and there's a boy waiting for her in her room. 11-year-old boy said, well, hey, good news, I'm a girl. And the school said, I can stay in your room. Come to find out, the school had not told the parents that their rooming policy, which separated students by sex, they had interpreted sex consistent with the Biden administration's new interpretation in Title IX to mean gender identity. And they hadn't told the parents a thing about it. So we are consistently seeing, despite school choice being now the norm in the majority of states across the country, we are continuing to see efforts to violate parental rights, especially in the public school system. But it's not just there. We see private schools doing the same thing. Because not all private schools adhere to what I call a Judeo-Christian view, a traditional view, in the words of Justice Blacklock, of gender identity. I mean, I just dropped my son off at Northwestern, which is not exactly purporting to be a Christian school, on Wednesday. And the first text I got from him on Thursday was, Dad, I just got invited to be a part of a group land acknowledgement. And we got to do it not just in English, but in all the indigenous languages. And the next text I got from him said, well, I just got invited to a BIPOC party. I was thinking like Forrest Gump, sorry for crashing your Black Panther party. But he goes to this BIPOC party, and come to find out they said, oh, sorry, we didn't mean to invite you because you're a white male and you're straight, so you can't attend. So he got thrown out of the BIPOC. He said this, and he just said, Dad, liberals are so silly. And I'm like, yeah, they are. So I immediately popped him back with a text that gave him the sign-up link for the college Republicans at Northwestern. I said, here are your people, son.
All two of them.
All two of them. You could be the third. But this is an issue right now. And so school choice will not solve the parental rights crisis.
It's not a silver bullet, but it is a part of the buckshot.
But it's a big part of the shot.
It's a big part of the buckshot.
Yeah.
David, so here in Texas, our law treats various education options a little bit differently. So those of us who are thinking about school choice and what the structure should be, can you tell us a little bit about how the Texas law looks at differences between public schools, private schools, homeschooling, parochial schools, charter schools? What's the regime look like for those?
Yeah, I mean, the bottom line is that Texas is one of the most friendly states to private education, private K through 12 education and homeschooling. There's almost no state in the union that's more friendly, absent the whole school choice issue. Well, that's my caveat. As Ryan mentioned, there is a part of the education code that if you send your kid to a public school, you have certain rights and responsibilities. Some of those include, access to the academic programs that they're learning, access to their records, to the teaching materials. You can go to the board meeting, yay. You can exempt your student from certain curriculum and instruction if it conflicts with your religious beliefs. And that's all well and good. I mean, that's in the Texas code, and it's great. The problem is, and I've seen this play out firsthand, is that to enforce this is nearly impossible because the mechanism is to file a grievance at your local public school. And I don't know if any of you have had time to ever file a grievance, but it's basically a waste of your time. I saw this play out when I was working for the Attorney General's office. We had some parents actually in the Tarrant County area who were concerned about curriculum that their kids were learning, and they had contacted the school asking for access to the curriculum, which you have a right to under the Texas Education Code as a parent. The school was kind enough to tell these full-time working parents, well, you can come and look at the material from 10 to 12 at the main district office, which is completely across on the other side of town, and we expect you to take time off from work to come do this. And so the schools kind of invent, with all respect to my colleague Tim here, the schools kind of invent these kind of creative ways to make it as difficult as possible for parents to actually understand what their kids are learning in the classroom. So the cool thing, though, is that Texas law expressly exempts students from having to go to public school if the student attends a private or parochial school that also teaches civics. And recently in Texas Education Agency versus Leeper, the Supreme Court of Texas held that homeschooling qualifies as a private school, something that we all kind of knew already, but they confirmed that for us, which we're very thankful for. And so, I'd say that here in Texas, at least, and this is going to be true in most states, that your parental rights are really at their apex if you send your kid to a private school or are able to homeschool them. And, the other thing to think about is private schools, religious schools, they sometimes get the added benefit of protection from other Texas laws. So during COVID, you might remember that most public schools shut down. Down in the People's Republic of Austin, where I live, they shut down for, I don't know, maybe like 18 months or more, depending on the school. And a lot of kids disappeared from the public schools and never showed back up. And it was a travesty. But at that time, when in the fall of 2020, as we were approaching the fall of 2020, at the Attorney General's office, General Paxton made the bold decision to say, let's write a letter to all the religious schools in Texas and make sure that we remind them that under the Texas Religious Freedom Restoration Act, they can decide on their own when to reopen. We don't have the right as the state to tell them when to close and when to open, and they have a religious liberty right to do that. And so you saw many schools reopening, much to the chagrin of local public health authorities, including in Austin. And so that's kind of the other things you need to think about when considering the pros and cons of sending your children to either a public school here in Texas or the private schools, or homeschooling them, which is probably your maximum enabling of your rights. But there are also these kind of added benefits in other parts of Texas law that you can take advantage of through those types of schools.
Don't forget another bold decision that was made right after that was a letter telling county public health officials they had no jurisdiction over public schools opening and closing policies.
That's right.
And that was up to each school board. And that's why you had, even in Travis County, Westlake schools, Lake Travis schools remained open while Austin ISD was shut down.
Right.
So that was also another significant sort of subsidiarity moment for Texas law.
You also had the People's Republic of Austin try and go after homeschoolers and learning pods specifically, in which some crazy moms said, we're going to pass a law to stop that. So that's where HB 1955 came from. But to pass that, because if you have a bad legislature, which will happen if we don't change the trajectory of the 90% of kids in the state of Texas that are receiving a public education, they will try and uphold laws from crazy people like those in Austin and San Francisco and other far left places.
Yes. So Tim, you've been pushing back against some of that. Well, I guess your clients have been pushing back against some of that craziness. You told us why. Tell us a little about what. Who are the school districts? What are the issues involved? And then how are those folks, those school board members, being received in the communities where they live?
Yeah, so to kind of put finish the loop on that story about our cultural competence action plan, some of our parents in our community got together and did what any reasonable group would do and hired Jonathan Mitchell.
Let that sink in for a moment.
And one of my legal heroes, Dusty Fillmore, who's in the room with us today, and they filed a lawsuit, and they stopped that plan on some grounds where we caught those trustees. They were deliberating in violation of some Open Meetings Act rules, and totally put a stop to that. And then through the political process, changed the dynamics of that board, and so that's not anything that we have to worry about anymore. So now, I guess to the other side to that question is once a group has a school board, what are some of the things that they are doing? I'll disagree a little bit. I love the grievance process. Controversial. Because for a responsive board, it's probably the quickest way to get some changes here. Some of my clients have taken some great provisions of the education code and actually turned them into local policies. And the reason that that's important is because in Texas, you all probably know that we have lots of really brilliant, great laws, but oftentimes there's no penalty for their violation. When a board will do this, and when they'll take great provisions of the education code, say on something like educational materials, for instance, and turn that into a local policy. If there's a violation of that policy, then it can go through the grievance process. And a parent can speak very quickly to those violations and hopefully get a remedy from a board that would be responsive. Another thing that one of my clients did, during COVID, there was a lot of attention to the content, I think you've talked about it already, of some library books. And I think that received a lot of attention in the culture. One of these school districts created a book challenge or book review committee and told parents, we would love to have your input. Please come and talk with us. Be a part of this committee. If there's a book you don't like, you can help us review it. And then when they showed up, they were presented with a very beefy non-disclosure agreement that said, if you want to participate in this committee, then you need to sign this non-disclosure agreement that you're not going to talk about what we talk about in here. And that's amazing if you think about it, that the government is saying, come, participate with us. We'd love to have you, but don't talk about anything. Don't say anything about what we're going to do in here.
That's because TASB, Texas Association of School Boards, I'm not going to say who their attorneys are because I don't know if y'all work for them or not. I don't think so. I'm going to go with not. But that's what they do. 1,200 school districts. Sorry, I just needed to
That's all
insert
right.
that
Yeah.
because they get guidance
Yeah.
and then they're told, but you can't say anything out loud. And school board trustees have that too. There's called the Rule of 8. You can't disagree with the president of the school board. You can't bring anything up. So
There's a direct
Parents
line from
and-
Gramsci to the TASB
Yeah.
group. So it's like Gramsci, Marcuse,
all
TASB.
of
That's
it,
right.
all of it flows through.
Yeah.
Sorry, I just had to throw that in there. Keep
No,
going.
thank
Sorry,
you,
I didn't
thank
interrupt
you. Because fortunately, what this board did is a few months ago they released everybody from those non-disclosure agreements. So they're taking proactive, bold steps in that direction to say, no, here is the content that we were finding in these books and these educational materials. Now in Texas, we have a very strong policy on what can and cannot be in educational materials, both in the classroom and in libraries, and those boards were taking those steps as well. And then on the issue of, we beat up a lot on California, and if you're a Harvard grad from California, you're having a rough day. But in Texas, what we've seen is the opposite to what California is doing. And these boards are saying, if we have a student, and this is a policy in most of the districts that I do work for now, I think in all of them, if we have a student that comes and wants to be identified by a different name or wants to be identified by a different pronoun, you have to tell the parent within 24 hours of that request from the student. And so I've been really proud to see that kind of opposite type of policy spring up in these districts that truly do have good boards that are concerned about these issues.
Tim deserves some great credit because one of his clients sued the Biden administration and got an injunction against Title IX.
Yeah.
And so that was just outstanding work by Southlake. And they also made the almost even more stunning, courageous decision to hire ADF as their lawyers, which I give you great credit for. But that was a lot of fun to be representing you guys.
Yeah, our friends at ADF have done a fantastic job.
So last question, very briefly, we only have about 2 minutes left. I'll just start at the very end with this, and if you have a response, please offer it. This is a little bit more policy, but some worry that any oversight by the state regarding funds or curriculum to private schools or homeschoolers under a school choice program would ultimately eliminate Texas's strong protections for homeschooling. What do you think about those arguments? Is no strings attached possible, or is academic and fiscal oversight necessarily invasive and ultimately destructive?
Starting with me, well, I think Mandy is probably the most qualified to answer that question. But I will say, I don't think that school choice is incompatible. In fact, I think school choice and parental rights go side by side. And I think that they're very, very compatible and they're complementary with each other. The reality is that parental rights are not absolute, and we know this. Parental rights are not absolute trump cards. For instance, no one is challenging the state requirement that children educate their kids, that parents educate their kids up to a certain age. And the state does have an interest in ensuring that children are well formed. Parents have the primary, not the subsidiary duty in carrying that out. And the state is simply there to support that primary interest. And there are, my wife is a CASA and she does work in that space, so there are instances where parents drop the ball and the state does have to step in. But the reality is when the state has to step in and discharge parental duties and obligations, that is highly destructive to the societal fabric. And I don't think that you're going to see that kind of dynamic with school choice. I think it's just the opposite. I think empowering parents to make those decisions about their children's education is entirely consistent with and compatible with parental rights. And even if the state does have some ongoing, I don't want to say supervisory role, but some sort of ongoing role in mediating that, that is not incompatible with parental rights in any way.
That's great. So I'll just speak directly to the legislation that was put forth in the regular session and 4 special sessions that did not pass, the education savings accounts. So yes, there's been court cases across the country. You've got Espinoza v. Montana, Carson v. Macon. Attorneys, I'm sure you know a lot more about what those are. But the way that the legislation here in Texas was written was set up where that it's called an education savings account. It's not a voucher of the past that started 35 years ago where there's a direct transfer of money from the state to a private institution. Rather, if you choose to utilize your options and you need to remove your child and want to remove your child, you apply for an education savings account. And then a portion of the funding is put in an account that is held by the comptroller. So no money's ever directed into a parent's bank account. We're not, taking vacations to Hawaii or Disney World. It goes into an account that's held by the comptroller and administered by an education administration organization. Again, 32 other states plus the District of Columbia have some form of private school choice. These are businesses that are set up that get approved goods and services, and it's a marketplace. So parents can direct, parents, not the state, parents say, I'm going to pay for private school tuition. The mean private school tuition in the state of Texas is $9,800. Just, we're not talking, Hockaday and Cistercian or whatever prices. We're talking like there's a lot of good people out there that realize there's a problem and want to educate kids. So parents can transfer that. It can also be used, one, it has to be an accredited private school. Accreditation through 19 different accrediting bodies. They have financial audits, education audits, all that good stuff. But parents can also direct it to therapy, tutoring, fee-for-service transportation providers, co-curriculars, career and technical education. We have a law that was passed a couple years ago that says that now 16-year-olds can start training for things like HVAC, electrical, plumbing, things like that. Things that we have a massive shortage in across the state of Texas. We are projected to be short 10,000 electricians, 6,000 plumbers, 4,500 HVAC workers, and the list goes on and on and on. So the parents, and at whatever time the child is older and able to help, they really get control of what their education is going to look like so that they can launch and reach their full potential. Now, it's opt-in for both parents and schools. There is no school that is forced to take an ESA. There are also strong provisions written by excellent attorneys. Institute for Justice has been helpful. Of course, hundreds of them have reviewed it to make sure that there is clear language in there that ensures that admissions, creed, practices, hiring, testing, all of that, nothing has to change if a parent directs the money to a private school. And finally, what's really important, and this is why I find this so important, having 3 young children, that I'm watching a world of chaos. The instability that we are seeing now is going to continue to get worse if we do not course correct an entire system. It's important to note that it takes freedom fighters to stop the overreach of the government, to not buy into groupthink and cancel culture and all this other nonsense that goes on. Education savings accounts and school choice, you have to have strong legal provisions, obviously, to protect and protections. But if we have more generations of children growing up to be insane, they're crazy, y'all. And in case you didn't know, by the way, if y'all remember the girl that made the love letter to Osama bin Laden go viral a couple years ago, right? Like, oh, I understand why he wanted to bomb America. Y'all, she graduated from high school at Thomas C. Clark High School right outside of San Antonio. It was a Texan, went viral across the world. This is going on. If we don't change it, these kids grow up, they vote, they will change the makeup of the legislature, and then we won't be able to go and pass the laws or uphold the laws. They can easily vote against private schools, homeschool, all of this. It is crucial to save the republic. It is very serious. I mean, we are at a tipping point. We have got to change what's going on in our school system. So yes, we can protect private schools, legal autonomy, parents' rights. We can also open the door for parents to push back in the school system like they are doing in really great conservative wealthy districts. That is not going on in other places. We have got to change what is happening in schools because these kids grow up and they vote and they will change the laws for the worse.
Well, please join me in thanking our panel this morning.